anticipatory bail. Now it is covered by section 482. Section 482. The first code that was enacted in India was Code of Criminal Procedure 1898. That was replaced by 1973 code. And 1973 code has been repealed and replaced by BNSS of 2023. So in India, we have had 3 criminal procedure codes at different periods. In the first code of 1898, there was no provision to apply for anticipatory bail. No provision in 1898 code. So the Law Commission in the 41st report, recommended insertion of a provision for anticipatory bail. And accordingly, in 1973 code, 438 provision was made for anticipatory bail. And in the present BNSS, some changes have been effected in the old provision 438. In 438, subsection 1, the consideration for the bail was found a place. The consideration for granting a bail found a place in 438(1). But that has been omitted now. What are the considerations for granting bail? The legislature has not made any instruction under the BNSS. Then, in 438, there was a specific mention that the court can pass an interim order of granting bail, for granting bail. That has been omitted now. Then there was another provision which said that if interim order is not granted or the anticipatory bail application was rejected, the police officer was free to arrest the accused. The reason was that there was an impression that once anticipatory bail application is filed, during the pendency of the application, the police cannot touch him. Now, under section 438, it was made clear that mere pendency of bail application, anticipatory bail application, is no reason for the police officer not to arrest him. If he is available for arrest, he may arrest him. Now, that does not find a place in BNSS. Then, it was necessary to issue notice to PP under the CRPC 438, but that is not included in BNSS 482. Then it was made clear in section 438 BNSS that in rape cases 376 A, B, C, D, etc., the provision for bail, anticipatory bail application was not applicable. So it was an exception. If an accused involved in rape cases, whatever may be the nature of the rape, was not entitled to anticipatory bail. Now, the provision says that only a person who is involved in the offences under section 65 and section 72, section 72, yes. See, nothing in this section shall apply to any case involving the arrest of any person or accusation of having committed an offence under section 65 and subsection 2 and section 70 of the Bharatiya Nyaya Samhita. Section 65 applies to persons, 65(2) apply to persons below the age of 16 and 70 to persons below the age of 12. Actually, it was not necessary because POCSO is there. Anyway, this is a general provision, so we can notice. So this is an exception. A person who is not entitled to file anticipatory bail application is provided in subsection 4. An accused who is involved in an offence under section 65 subsection 2 and section 70 of BNS, they are not even entitled to file an anticipatory bail application under the BNSS. Okay. And remember that under the BNSS, as you all know, a criminal procedure can be amended even by a state. Even by a state. The only requirement under the constitution is that he should get the assent of the President of India. So in Uttar Pradesh, until 2018, section 438 was not applicable in Uttar Pradesh. There was no provision for filing an anticipatory bail application because 438 was deleted by state amendment. Only a writ petition was maintainable. But in 2018, as I understand, that's why inserted. Now, under section 483, unless a state amendment is there, and anticipatory bail application can be filed by any person in any state, unless it has been taken away by a state amendment. Then, what is the object of this anticipatory bail? What is the object of this anticipatory bail? You can see it in the 41st report of the Law Commission, which recommended provision for anticipatory bail. 41st report of the Law Commission of India. And that was recommended by 42nd report of the Law Commission also. So 41st and 42nd reports of the Law Commission pertain to this requirement or desirability of having a provision for anticipatory bail. The object is clearly mentioned there. The object is to relieve a person of unnecessary harassment or disgrace. If the court is of the opinion that he will not misuse the liberty, then he will not abscond, etc. That was necessary to save him from humiliation, disgrace, false implication by enemies, by influential persons, political enemies, etc. So that was the objects mentioned in the Law Commission reports. You can see them in 2002 or the latest one. I will give you these important decisions. That is AR 1980 Supreme Court, 1632, which is a Constitution Bench decision, a landmark judgment so far as anticipatory bail is concerned. Landmark judgment, everybody should read it. Landmark judgment. Gurubaksh Singh CBI versus CBI. It was followed by 2019 Volume 9 SEC 63. The court observes that the object of an arrest or filing a case should not be, or it should not be a motivated one. If it is filed with, if the case is taken with ulterior motive, then it's a fit case for granting anticipatory bail. Then the intention of the complainant is only to humiliate him, the accused. Then it's a proper case for filing and granting anticipatory bail. The latest decision, which gives the object of anticipatory bail, is AR 2024, Supreme Court 4557. It is stated that the object of section 438, now 482, is to recognize importance of personal liberty and freedom in a democratic society. In India, it is guaranteed by Article 21 of the Constitution, liberty, and the preamble of the Constitution also. See, what do you mean by anticipatory bail? The term is not defined. It had not been defined in CRPC of 1973. It is not defined in BNSS also. So what is its meaning? The Supreme Court has observed that it is not bail before arrest. That is not the meaning. That is not the meaning. Yes. So I will explain it. So the term anticipatory bail is a misnomer. It's a wrong term. It's a wrong phrase actually. So the term anticipatory bail is a misnomer because the court does not pass any bail order. The court does not any order to order grant him bail. AR 1977 Supreme Court 366. Then what is that order? What's that order? You read section 483(1). A high court or court of session may direct that any person accused of an offense and in custody be released. 482 it is. 482. Please show it on the screen. 482. Then you will understand the S, where any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offense. He may apply to the High Court or the Court of Session for a direction under this section. So the request in the application under section 482 is to give a direction. What is the direction? That direction is that if he is arrested or if he happens to be arrested, in the event of his arrest, he shall be released on bail. So it is not an order granting bail. It is an order directing him to give bail. That's the difference. It is not order of granting bail. It is an order for granting bail. See the prepositions, different preposition. It is not an order granting bail. It is an order for granting bail or for releasing on bail. And by that order, nobody is released on bail because the applicant is not in custody when he files the application for anticipatory bail. So it is a misnomer, and it only means that it is a direction for release the applicant on bail if he happens to be arrested. Order for the purpose of granting bail. Order for the purpose of not granting bail. Order for granting bail. If he happens to be arrested, he shall be released on bail. It is not the Sessions Court or the High Court that grants him bail. The court only directs the police to release him on bail if he is subsequently arrested. No bail order is passed by the court. The court does not pass a bail order under section 482. old section 438. So it's a misnomer that it is the term anticipatory bail is a misnomer. It's not actually, does not give the clear picture. Yes. Then what's the nature of the rights? What is the nature of the right under section 482? The nature of the right under section 482 is neither constitutional, is not constitutional right or a fundamental right. The right to anticipatory bail is neither a fundamental right nor a constitutional right. It is only a statutory right. It is a right created by BNSS. It cannot be claimed under the Constitution. 2024 SEC Online 2453. 2453. Then, who can grant anticipatory bail? So, this is a technical term, anticipatory bail, used by the legal profession, and we also will use that term, anticipatory bail. So, who can grant anticipatory bail? Only two courts, Sessions Court and High Court. And the power is concurrent. The power is concurrent. Means at the very same time, either the High Court or the Sessions Court may exercise that power. The applicant is entitled to file an application either before the Sessions Court or the High Court. The High Court cannot direct the accused, you go to Sessions Court first. No. It is a concurrent power that may be exercised by High Court or the Sessions Court and the Sessions Court. So the bail other than the anticipatory bail is called regular bail. Regular bail, in contrast to the anticipatory bail, the bail granted under section 480, as we have seen by a magistrate, it is called regular bail. And in contrast, the bail under section 482 is called anticipatory bail. So when we call the power under section 480, that is to grant regular bail, the question that may arise for consideration is whether the power under section 482 to grant anticipatory bail is an exceptional or special one. Can it be said that the power under section 482, that is anticipatory bail, can be exercised only in exceptional or special cases? There were some decisions of the Supreme Court, or at least one decision to the effect that it could be exercised only in exceptional or special cases. But that has been disapproved by the Constitutional Bench of Supreme Court. Already we have seen Guru Bakht Singh, Sibia, AR 9 is 80 Supreme Court, 1632. Wherein the Supreme Court, the Constitutional Bench has said that it can be exercised in any case where the facts justify it. It need not be an exceptional case. It need not be a special case. But the right is of extraordinary character. The right is of extraordinary character. And ordinarily, it is not resorted by people because the ordinary rule, they can approach the court under section 478 in the magistrate court. This is the view taken by the Constitution Bench in Sibia, Guru Bakht Singh. So we have seen that the order passed by the court is only a direction and not a bail order. So the nature of the order that may be passed by the court, the nature of the order that may be passed by the court is a direction to the police, a direction to the authority concerned to release him on bail if he is arrested. What does it mean? No bail order is passed by the court, and the court cannot restrain arrest also. The court cannot issue a direction that the particular applicant shall not be arrested. In a bail application under section 438, now 482, the court cannot issue a direction to the police officer not to arrest the applicant. Because the only direction that may be passed is, if he is arrested, he shall be released on bail. AR 77 Supreme Court 366. Then, what is the foundation for application? What is the foundation for an application that is an anticipatory bail application? It is specifically mentioned in section 482. When any person has a reason to believe that he may be arrested on accusation of having committed a non-bailable offense. So the first is that he must be a person accused of a non-bailable offense. And the offense is bailable. If the offense is bailable, anticipatory bail application is not maintainable. Why? As members of the legal profession, we must always ask three questions ourselves. One is what, the second is how, the third is why. And here, what the answer you will get in section 482. Yes, you are right. The reason is that in a bailable offense, the accused is entitled to bail as of right. As of right. Now, no court can deny him bail. So he need not apprehend that he will land in jail. That's the reason. Simple thing. So the offense should be a non-bailable offense. Then, what is the foundation? The foundation is that he has reasonable belief that he may be arrested. In other words, he has a reasonable apprehension. So the foundation for application under section 482 for anticipatory bail is reasonable apprehension on the part of the applicant that he may be arrested. And see, the phrase used is reasonable. He has reason to believe. Reason to believe is different from, or we can say that mere fear is not sufficient. Mere fear of the applicant that he may be arrested is not sufficient. It is not a reasonable ground. So he should disclose in his application why he apprehends. What is the reason for his apprehension? The applicant in a bail application, anticipatory bail application, should disclose in the bail application why he apprehends that he may be arrested, so that the court may reach a conclusion that his apprehension is reasonable. So the facts which would incline the court to say that yes, his apprehension is reasonable should be disclosed in the bail application. AR 1980 Supreme Court 1632 Constitution Bench. What should be the contents of the application? What should be the contents of the application is given in a subsequent Constitution Bench, that is Sushila Agarwal's case, another Constitution Bench AR 2020, Supreme Court, 831. These two decisions I will be mentioning every now and then, because so far as the anticipatory bail application is concerned, these are the two important decisions, landmark judgments of the Supreme Court. Then, in a subsequent decision or the latest decision, the Supreme Court has said that the specific events and facts necessary for the court to decide whether the apprehension is reasonable or not should be disclosed in the application. That is, specific events and facts which incline the accused or which compel the accused to believe that he will be arrested. It should be disclosed in the application. The latest decision is 2024 SEC Online, Supreme Court 2453. Yes, equivalent LiveLaw citation may be there. Now, who can apply? What is the stage of the stage at which this application has been filed? Only a person who has not been arrested can file an application under Section 482. If he has already been arrested, there is no question of invoking Section 482. In other words, Section 482 is a pre-arrest remedy. Pre-arrest is a pre-arrest application. After the arrest, the provision is Section 480. Then, what is meant by arrest in this context? There may be different types of arrest. We have seen that arrest to be effected by, unless the accused submits to the custody of the police officer, it has to be arrested by touching the body, confining the body, and if he resists, the police officer can use force. We have seen. That is called actual arrest. That is called actual arrest. Real arrest. But there is another kind of arrest which is known to the law, legal profession, that is formal arrest. Yes. So the second kind of category of arrest is formal arrest. In other words, it is called a paper arrest. It is called paper arrest. And formal arrest sometimes is made when the accused is already under arrest. He is in custody. When a person is in custody, it is sufficient for the police officer to record that he is arrested. Just inform, yes, you are arrested. He may be in jail. Even in jail, suppose one person is in jail in connection with one case, and it is necessary to arrest him in a second case. The police will go to the jail with the permission of the magistrate who remanded him, and will effect his arrest. He will just make a record and inform him that you are arrested. In that case also, this is called formal arrest or paper arrest. The Supreme Court said that even a person who has been arrested, or if the arrest is a formal arrest or paper arrest, he also is entitled to maintain an application under Section 438, that is a 482. A person who has been only formally arrested, or the arrest is only paper arrest, is only on record, he is not disentitled from filing an application for anticipatory bail. Sorry, 2024 SEC Online, 2453. Yes. So what is the stage of the proceedings? Investigation is the proceedings. So what is the stage of the investigation, or what should be the stage at which an application can be filed under section 482? We have already seen that formal and paper arrest. Formal arrest means there is no real arrest because he is already in detention. He is already in custody. So they will make a record that he is under arrest in this case also. That's all. There is no real arrest because arrest means stop him. He need not be stopped. His liberty need not be taken away because his liberty has been taken away. That is called formal arrest or paper arrest. This is the phrase used by the Supreme Court in this decision. Okay. Now, what is the stage at which? What is the stage at which this application may be filed? We have already seen that an investigation in a cognizable offense commences when the officer gets information. Yes, I will explain it. We have seen that investigation in a case can be or commences after an information as to the commission of a cognizable offense is received by the police officer as such. So it is the receipt of or receiving the information about commission of a cognizable offense that paves the way for investigation. Information is the cause, investigation is the effect. So here the question is, at what stage a person can apply for this pre-arrest bail or the anticipatory bail? Can he file an application before an FIR is registered? That's the question. Can it be before FIR? He files an application and the prosecutor will say that he is not an accused. There is no FIR. Why should he come to the court? That is not a justification. Even where no FIR has been filed by the police officer, an application under section 482 for pre-arrest is maintainable. So even before the FIR is prepared, FIR is filed, an application for pre-arrest bail is maintainable. (2012) Volume 8 SEC 730. And this was been reiterated by the Constitution Bench in Sushila Agarwal, AR 2020 Supreme Court. AR 2020 Supreme Court. Yes, even without an FIR, an anticipatory bail application can be filed. This has been confirmed by the Supreme Court in Constitution Bench, AR 2020 Supreme Court 831 Sushila Agarwal's case. Yes. So in this context, another question may arise. Can an anticipatory bail application be filed after the final report, but the police report is filed after investigation and the court has already taken cognizance of? In rare cases, it may happen. The question is whether he can maintain an application after the police report, that is final report, is filed and the court has taken cognizance. The Supreme Court says there is no bar. An application under section 482 for anticipatory bail application is maintainable even after the final report is filed. What if FIR is never filed, but the anticipatory bail application has already been applied for? I will explain it. So even after the final report is filed and My state has taken cognizance. Yes, that is a charge sheet is a final report. See, CRPC did not use the word charge sheet, only final report. But in BNSS at some place, the word charge sheet is filed. It is improper to use that term. It is only police report. Because only that is defined in this BNSS. Okay. So even after the filing of the final report and the courts taking cognizance of the offense, a bail application under section 482 and application under section 482 is maintainable. 2010 volume 1 SEC 684. Yes. Again, AR 2023 Supreme Court 4662. 4662. Then, one accused is in custody in one case. A person is in custody in one case. A second case is there against him, or he apprehends that he will be arrested in another case. He is already in custody in one case, but he apprehends that he will be arrested in another case. Can he maintain an application of section 482? A person who is already in custody in connection with one case, there is no bar. In another case, he may apply for anticipatory bail. There is no disqualification. 2024 SEC Online 2453. Yes. Another question which may arise is whether an absconding accused is entitled to file an application under section 482. An absconding accused or a proclaimed offender. The view taken by the Supreme Court is that he is not entitled to file an application. Ordinarily, he will not be entitled to maintain an application. 2012 8 SEC 730. So now we go back to the section. When any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offense, he may apply to the High Court or Sessions Court. So only two simple things. One, he should be accused of a non-bailable offense. The second is that he apprehends that he will be arrested. Reasonable apprehension that he will be arrested. These are the only two requirements of section 482. But what are the considerations before the court for granting bail? These considerations were mentioned in old section 438 CRPC, but as I have already told you, that has been omitted. But they are the same considerations. Or more can be there. These considerations can be understood from the objects I have mentioned. That this case may be a false one. The only purpose is to humiliate or disgrace the person. He is not likely to abscond. And it is because of political rivalry, only because of personal animosity. Then it is a motivated one. It is with ulterior motive. So these are the considerations, but they have been deleted now. Then the considerations mentioned in section 438(1) is a guidance actually now. The nature and gravity of the accusation, that is always most important in a case of bail, anticipatory or regular. The nature and gravity of the accusation, the antecedents of the applicant, including the fact as to whether he has previously undergone imprisonment on conviction by a court in respect of any cognizable offense, the possibility of the appellant to flee from justice, that he absconds. Then, where the accusation has been made with the object of injuring or humiliating the applicant or having him so arrested. These are the considerations. That is, for and against. For and against. See, these are the considerations I have already mentioned. Political enmity, personal enmity, only to disgrace this man, only to humiliate him. It is motivated. These are negative facts. That means these are facts which would incline the court to grant him bail. But if he has already been convicted in another case, then the court will not be inclined to grant him bail. Negative one. Then, yes. Then another factor which may be relevant is, so you can note down one decision, considerations for granting anticipatory bail. 2011, 1 SEC 694. What are the considerations? Then, conduct of the applicant is relevant in deciding whether he should be granted anticipatory bail or not. Conduct of the accused. 2009, Volume 9, SEC 414. So, what should be the nature of the order that should be passed by the courts? The section only says that. There shall be a direction that in the event of his arrest, he shall be released on bail. The arrest is effected by police. So if the police arrest him, he shall be released on bail. But there is a caution by the Supreme Court. When an order is passed, it should not be a blanket order. So there shall not be a blanket order for granting him bail by the person who subsequently arrests him. What do you mean by blanket order? By blanket order, we mean that without specifying the offenses in respect of which he may be granted, not without any condition. No. Condition is always there. No person can be released on bail without a condition, except in the bailable offense case. It is not condition. There will be condition, we will see. But it is this, the court should mention the offenses for which he may be released on bail. So in the bail order, if it should be mentioned, if he is arrested for the following offenses, he shall be released on bail. And without specifying the offenses, no order shall be passed. Why? See, in the investigation at the initial stage, minor offenses might have been revealed, but subsequently it could be revealed, yes, no blanket order. It could be revealed that he has committed some major offenses. So the police will be unable to arrest him. There is already a blanket order without specifying the offenses for which he has been granted anticipatory bail. So the offenses should be specifically mentioned in the anticipatory bail order. Otherwise, armed with this blanket order, he will escape from the clutches of the police, even in very serious offenses. So no blanket or no bail order without mentioning the charges against the applicant, right? That is it. So the blanket order should specify the offences for which he has been granted bail. Then the order should not be in such a way that he may commit any offence in future also. The order should not be, the nature of the order should not be such that he will be able to commit, or he will go scot-free even if he commits later some offences. No. That first decision that no blanket order shall be passed is AR 1980 Supreme Court Section 32. AR 2009 Supreme Court. (502). The latest decision is, I don't have that citation with me except this Kerala journalist there. Mr. Rohit may give you. Priya Indonia versus Karnataka state. That is with regard to the anticipatory bail. Justice Nagaratna of the Supreme Court. Year is 2023. 23, I have the judgment before me, but the citation you may not got because this is a different one. It is reported in a Kerala journal, that is KLD 2023-15 SCR Supreme Court reporter, INSC also 1008. Yes. That is a very important decision, the latest decision on the point as far as anticipatory bail application is concerned. We will discuss it in detail later. So the next question is, can conditions be imposed? Can conditions be imposed while granting anticipatory bail order? So we have seen that the court does not pass a bail order. It will only direct that he shall be released on bail in case he is arrested. So the bail is actually given not by the court, but by the police. But there will be a direction that when he is released on bail, in the bail bond, the following conditions also should be included. So you can see it in subsection 2, 482. Such conditions, such directions, the light of the facts as it may think fit, including. So all these are not the only conditions. Yeah. It's 8:56. നീ പോയി കിടന്നോ, ഞാൻ വന്നോളാം. എവിടെയെങ്കിലും നീ കിടന്നോ, ഞാൻ വന്നോളാം. ഞാൻ വന്നോളാം, നീ കിടന്നോ. ഞാൻ ഇറങ്ങിക്കോ. വേണ്ട, നീ ഉറങ്ങേണ്ട സമയം കഴിഞ്ഞില്ല. Some conditions are mentioned. No, it is not muted now. I have unmuted. Can you hear me now?
Yes, sir. We can hear you, sir.
Yes. So some conditions are mentioned in subsection 2. It does not mean these are the only conditions. The section itself says that the conditions may be imposed by the court, which it may think fit. Those conditions may include the following conditions. That is, it is not exhaustive. A condition that the person shall make himself available for interrogation by a police officer as and when required. So that means the police will ask him to appear before the police on a particular day, at a particular time. Then he has to obey it, because he has to be interrogated under section 161 CRPs old. Then a condition that the person shall not directly or indirectly make an inducement, threat, or promise to any person acquainted with facts of the case so as to dissuade him from disclosing such facts. Yes, 180 now. Facts to the court or to any police officer. That means he shall not interfere with the investigation. He shall not influence the witnesses. He shall not tamper with the evidence. Then, a condition that the person shall not leave India without the previous permission of the courts. So, a condition may be imposed that he shall not leave India without the permission of the courts, not absolute restraint. And to make sure that he complies with it, sometimes the court may direct that he shall deposit his passport with the police officer or in court. It is not impounding. Then, such other condition as may be imposed under subsection 3 or section 480, as if the bail be granted under that section. So this is as good as a bail order under section 480, a bail granted under section 480 by a magistrate. So any condition that is mentioned in section 480, subsection 3, also can be imposed. There is no bar. So what is the purpose of imposing conditions in a bail order? What is the purpose of imposing conditions in a bail order? You will get the answer in 2024. SEC 415. Yes, the main purpose is to ensure that he does not defeat the investigation. It is only for the purpose of proper investigation, and that he will appear before the court. That is to ensure his presence in the court later. But the conditions shall not be arbitrary. The conditions shall not be arbitrary. And they shall not be onerous, which we saw yesterday, and impossible for him to comply with it. 2024 8 SEC 293. The conditions shall not be harsh. The conditions shall not be harsh, because this is not to punish him. 2009 4 SEC 45. The conditions shall not be harsh. Yes. Then again 2020 AR 2020 Supreme Court 831 Sushila Agarwal's case. The court may impose special conditions depending upon the nature of the offense, nature of the case. Constitutional bench. Often a question arose whether the anticipatory bail should be for a limited period. So when bail order is anticipatory bail order is given, some courts used to say that it can be only for a limited period, for 1 month, for 2 months, for 2 weeks, etc. There were decisions in support of that view, but those decisions did not take notice of the observation of the Supreme Court in the Constitution Bench, AR 1980 Supreme Court 1632. Gurubakh Singh Sibia. The law is that ordinarily it shall not be for a limited period. It should be indefinite. This has been reiterated by the last Constitutional Bench decision, Sushil Agrawal 2020 AR 2020 Supreme Court 831. Yes. Then sometimes it may happen. Anticipatory bail is for indefinite period. Yes, ordinarily it shall not be for a limited period. It shall be until the conclusion of the trial. Yes. Now an interesting question may arise. Yes, an interesting. There have been many decisions on this point. I have given you the latest one. That is, it can be ordinarily. It is for not for a limited period, but there may be special cases where the court can say that it is available only for a limited period. Exception. That's an exception. So Sushil Agrawal's case, the latest decision, you can go. Or even you can see it in this Nagaratna's, Justice Nagaratna's decision. That is only a 2-judge bench decision. That is why I did not refer to it. The earlier one I told you. Then an interesting question may arise. We know that we are all now, or many Indians, they belong to a particular state, but they may be employed in another state or even in a different country. So our lifestyle has changed. So it may happen that he may commit an offense in one state and he may leave that state. Or he may commit an offense in a particular district and he may leave that district for another district. So where should he file this application? Where should he file this application? This question has arisen. In one Kerala decision, the only Kerala decision, only one decision is on the point, that is Kerala decision. What is the effect of granting anticipatory bail by a court having no jurisdiction? So take a case where the offense was committed in one district in Kerala and the accused left for Tamil Nadu. Can he file an application in Tamil Nadu, or should he come back to Kerala in that particular district and file an application either in the High Court or in the Sessions Court consent? What is the effect of that order? These two questions arose. Ultimately, we will see that in Justice Nagaratna's decision, before that, there was a decision of the Kerala High Court. I think that is the only that has been referred to in Justice Nagaratna's decision. That is 1984 KLT, 1984 KLT, Kerala Law Times, 942. No, it's not actually transit anticipatory bail. It is a different method. Only we are on the question, what is the effect of that order? Effect that of order. Transit bail is a different concept. Here we are only considering what is the effect of an order that is passed by a court having no jurisdiction to inquire into or to try that offense. See, the view taken by the Kerala High Court is that if the order is passed by a court having no jurisdiction, it will have effect only within the jurisdiction of that court. An anticipatory bail order passed by a court having no jurisdiction has effect, or it will operate only in that district or in that jurisdiction. And if the accused is arrested in that particular area, he will get the benefit of it. Take a case where a Delhi court has territory jurisdiction. But he is in Madhya Pradesh. See, apprehends that he will be arrested in Madhya Pradesh. And he files an application in a court in Madhya Pradesh. The court passes an order, Sessions Court passes an order, or even the High Court passes an order. Can he get the benefit of that order when he goes to Delhi? He has not obtained the order from Delhi court which has jurisdiction, but the order is obtained from a court which has no jurisdiction. So Kerala High Court took the view that if the order is passed by a court having no jurisdiction, take the case where it is a Madras High Court, Madhya Pradesh High Court, then the area of its operation, the order will have effect only in the state of Madhya Pradesh. If he happens to be in Delhi, he will not get the benefit of this order. But if that order is passed by the Delhi High Court, he is entitled to that benefit across the country, all over the country. Such a distinction has been made by the Kerala High Court. 84 KLT 942. This has been referred to in Justice Nagaratna's decision, which we will consider later. Then it has already been mentioned that the only direction that may be given by the court is that in case he is arrested, in case the person is arrested, he shall be released on bail. But some courts even now pass an order to the effect that the person shall not be arrested. That is, they will restrain arrest of the accused. Is it legal? Is it legal? The question has been answered by the Supreme Court in 3 decisions. The Supreme Court has taken the view that the court cannot restrain arrest. The court cannot restrain the police from arresting the accused during the pendency of this, or even after that, pendency of this application, or even after that. They have every right to arrest the accused. And the anticipatory application will come into effect only on arrest. Otherwise, it is meaningless. So, the arrest cannot be restrained by a court hearing anticipatory bail application. AIR 2005 Supreme Court 1057. year 2009 Supreme Court, 502. 502. 2012 5 SEC, 2012 5 SEC, 690. But in spite of this, many courts even now restrain police from arresting the applicant. It is illegal. But remember, the Supreme Court sometimes restrain the accused, but the power is different. It exercises its own power under the Constitution. It can pass any order to do justice under Article 141 of the Constitution. See, the gist of these cases is this. If an application is filed for anticipatory bail, the accused will apprehend that during the pendency of this application, he may be arrested. And he will make a request that the court may direct the police not to arrest him. The Supreme Court says that the court has no jurisdiction to issue such a direction, that he shall not be arrested. Yes. So, in a bail application, during the pendency or even after the disposal of it, the court cannot direct that the accused shall not be arrested at all. That is Article 141 of the Constitution. So always remember that the power of the Supreme Court is under Constitution and they exercise that power in any case, and that is not available to High Court or Sessions Court. But unfortunately, without noticing it, many courts pass such an order in spite of these three judgments of the Supreme Court. Such power is not available under Section 482. Then, if an accused is released on bail, anticipatory bail, and subsequently the police understand that, realize that his presence is necessary, his custody is necessary for effecting a recovery of an object under Section 27 of the Evidence Act, is now Section 23 of the BSI. He has concealed some articles. It may be a weapon, it may be a stolen article, and he has already been granted, he has already been released on anticipatory bail. The question is, can the police or is the police helpless? His presence is necessary to effect the recovery under Article Section 27, now 23 BSI. So this was considered by the Supreme Court as back as 1980 in Sibia's case, Constitution Bench, 1980, year 1980 Supreme Court 1632. And latest decisions are also there. The Supreme Court has said that the power of the police to take him to the spot or to summon him to effect the recovery is not affected. In other words, even after the release of the accused on anticipatory bail, he may be summoned to the police station to effect the recovery. There is no impediment. The apprehension was that if he is free, that is not under arrest, not in custody, without taking him into custody, can the recovery be effected? That part, Section 27 of the Indian Evidence Act, now Section 23 of the BSA, provides that if the accused while in custody of the police, so here he has already been released on bail, so he is not in custody of the police. He is not custody of the police. At the same time, the concealed article has to be recovered. Without taking him into custody, is it possible? That was the question. That has been answered in AR 1980 Supreme Court 1632, that it is not actually taking me into custody. The right of the police is not affected. And this was followed by the latest Supreme Constitution bench, AR 2020 Supreme Court 381, AR 2020 Supreme Court 381, Sushila Agarwal's case. The term used by the Supreme Court is, it is really a custody, but it is called deemed custody or limited custody. For the purpose of section 27, he will be deemed to be in custody. For the purpose of section 27 Evidence Act, now section 23 BSA, the accused who has been released on the orders of anticipatory bail shall be deemed to be in custody. It is called deemed custody. The other term is limited custody. Limited custody. Then, the accused was granted anticipatory bail. Subsequently, he was arrested. The police found that his medical examination is necessary for some purpose in connection with the investigation. Can it be done? Can the medical examination of a person who has been released on bail under section 482 BSA, so BNSS, be conducted in another constitution bench decision, that is a Sylvie's case, AR 2010 Supreme Court 1974, AR 2010 Supreme Court 1974. The constitution bench held that even after the release of the accused, pursuant to the direction issued by the Sessions Court or High Court, anticipatory bail, his medical examination can be conducted. There is no bar. Yes. Now, mention has already been made that under section 438 CRPC, there was a mention about granting interim bail, sorry, interim protection or interim order of anticipatory bail. There is no such is under section 51 or section 53 of the BNSS. I don't know, actually it is which section, I don't remember that particular section. For different purposes, he may be examined. That is a rape case, he may be examined. Then in assault case, he may be examined. There is no bar. So inappropriate, yes, 51 rape only. Yes. Yes. Okay. Yes, no bar for medical examination. Then interim order. I was at interim order. Interim order. 63 is yes. Sorry. Okay. Then interim order. There is no such mention in BNSS. Interim order. That means application is filed, but the court is of the opinion that he should be given interim protection during the pendency, because it is necessary to give notice to the public prosecutor. Notice to public prosecutor is necessary to be given before anticipatory bail order is passed. AR 1980 Supreme Court 1632. Gurubakh Singh, Sibia. But here, there is no time to hear the prosecutor. The court is satisfied that this is a maliciously instituted proceedings. Is because of political enmity. Is the court helpless? The court is of the opinion that he shall be given a protection till a final hearing on the application is held. In such cases, until the disposal of the bail application, the anticipatory bail application, the court will issue a direction that if he is arrested, he shall be released on bail, and that will be applicable, effective, only till the disposal of the bail application. That is called interim protection, interim order. You will see it in AR 1980, Supreme Court 1632. Then, can anticipatory bail order, the bail granted to the accused on the basis of this order of the court, be cancelled? Yesterday we saw that regular bail application, if bail is granted under section 480, then it can be cancelled. Here also, there is no prohibition for cancelling the bail granted under section 482. It also can be cancelled on the basis of subsequent events. If he violates any of the conditions, that is 2009, I don't know whether you get this Rohit Meno parallel citation, 2009, 82, volume 82, AIC, All India Cases, 196, Supreme Court. Will you get an equivalent or parallel citation? See, the question is from Rohit, yes. The citation is 2009, volume 82, AIC 196, right? Yes. Now software is there, so I will delete it. No problem. Yes. Take a case where somebody put a question at the beginning. A person files an application under section 482 for anticipatory bail. He apprehends that he may be arrested, and he was granted bail by the court, or he was granted the order for direction, order that a direction was issued to the police that in case he is arrested, he shall be released on bail. But really, there is no accusation against him. There was no accusation against him. There was some suspicion, but the police never made him an accused. What is the effect of it? Can the police say that you have obtained a bail order from the court, so we will make you an accused? By filing an anticipatory bail application or even getting an order under section 482, a person does not become an accused merely because he has obtained an order of anticipatory bail. He does not become an accused. He cannot be made an accused for that reason alone. 2011, 2 SEC 632. Yes. So we shall call it a day. We'll continue tomorrow. The latest decision of Justice Nagaratna and some more points to be covered by this under this topic. So if you have any doubts, you may ask me.
Dear participants, in case you have any doubt, please ask. Aisha, Kritanjali, and Siddha Gangaya sir, I saw that you raised hands during class. If you have any doubt, please ask.
Yes. Yes. No problem. I think I have covered almost all the questions. I have answered all the questions which may probably come up for you. Yes. So we'll continue tomorrow. We'll continue tomorrow. And in case you have any doubts, even after the class, the trial by sessions are under 487. 480 is applicable only to a magistrate court. Only to a magistrate court. See, at the beginning it says, when a person appears or is produced by before a magistrate. When a person accused of a suspect commission of any is arrested or detained without warrant, yes, other than the High Court or Court of Session. That's why yesterday I told you it's applicable only to a magistrate, excluded. Yes. So there is no question of this section being made applicable to Sessions Court or High Court, which are the only other two criminal courts under the BNSS. So that means only magistrate courts, though it is not specifically mentioned. Okay. So good night. We'll meet tomorrow.
Sir, there is a question.
Yes.
One question.
What's that question?
Yes, sir. For is a consideration for granting bail under 480 the custody period? Period of custody can also be a consideration, sir, under 480.
Is it under section 480?
Yes, sir.
480, it is always that he has been in custody for a particular period. So his further detention is not necessary for investigation. The police had sufficient time to conduct the investigation. So that's always there. That condition, that will be always a consideration, the period during which he was in custody. But that alone will not be a ground to claim this bail. That alone may not be. It will depend upon the facts and circumstances of the case. Yes. So thank you very much. Good night. Bye.
Thank you, sir. Good night, sir.
Yes,
Good night,
good night.
everyone. Take
Yes.
care. We'll meet tomorrow.
Yes.